All right, good morning, everyone. Good morning. Welcome back. It's okay. Welcome back. Hopefully, you had a nice day yesterday. I was mostly in airplanes, but I did come back. Well, before we get started, I do want to show you a couple clips from testimony, if I can. People love movie day when you're in elementary school, but this is similar. So the hearing yesterday was very interesting. It started around 10 and about 3.5 hours with no break. It was grueling, but interesting. So the format's like this. There were 4 witnesses, myself, the Attorney General from Nevada, a law professor from Florida, another law professor from St. Louis, and we each got 5 minutes to speak uninterrupted. Grilled us with questions for the next 3 hours. And each representative gets exactly 5 minutes to ask questions, and they can ask whatever they want. And there's some questions of me, colleagues. So, because you can't get up and leave. More than that, I think I made some good points. So watch. I think I did. So you'll judge for yourself. I want to. Free watches for everybody. I didn't get a watch. Someone watched it. Okay, let's see. Was it fine? Oh yeah. Okay. So this is my opening statement. Let's see. Of course, it's not going to work. Try this. Everyone, calm down. Shh. Okay, this shows. Here we go.
Before this committee about this important issue. Thank you, General Laxalt. Welcome. I understand your parents are with us today.
My dad's the same color Todd, so
give a shout out to my parents, which was kind of nice too. Oh, come on. Stop buffering.
Please. Excellent.
Thank you. Chairman Goodlott, Ranking Member Conyers, and members of the Judiciary Committee. My name is Josh Blackman. I'm a constitutional law professor at the South Texas College of Law in Houston, Texas. I am honored to have the opportunity to testify about why DAPA violates the Constitution and poses a severe threat to the separation of powers. In my brief time, I have 3 points. First, DAPA is an unprecedented exercise of presidential lawmaking power and is not consonant with previous exercises of deferred action. Second, DAPA violates the president's duty to take care that the laws are faithfully executed, as the executive must enforce the laws in good faith. Third, I will sound an alarm. Non-enforcement poses an encroaching threat to the separation of powers and the rule of law that Congress, not just the courts, must take steps to halt. So first, Congress has not acquiesced or given the President the authority to implement DAPA. The Justice Department's Office of Legal Counsel claimed that 4 previous instances of deferred action justify DAPA and its antecedent DACA through express or implicit congressional approval. These claims are demonstrably false. So first, in 1997, deferred action was granted for battered aliens under the Violence Against Women Act, VAWA, where a petition had already been approved, but a visa was not immediately available. Here, the deferred action served as a temporary bridge for those who would soon receive permanent status according to the laws of Congress. Second, in 2001, deferred action was granted for aliens who were readily deemed to be bona fide under the Victims of Trafficking and Violence Protection Act. Here, too, the deferred action served as a bridge. Lawful status was immediately available on the other side of the deferral. Third, in 2005, deferred action was granted for foreign students who unfortunately lost their visas when Gulf Coast schools were closed following Hurricane Katrina. The deferred action bridged the gap and gave the students 4 months to enroll at another college or university in order to regain the status they previously held. Fourth, in 2009, deferred action was granted for aliens that were widowed by the untimely death of their citizen spouse before the minimum 2-year period. Deferred action was granted where visa petitions have been filed but not completely adjudicated by the government because of administrative delays, again, early after deferral. Historically, deferred action acts as a temporary bridge from one status to another, where benefits were construed as immediately arising post-deferred action. In contrast with DAPA, deferred action serves not as a bridge, but as a tunnel to dig under and through the INA. There is no visa, the proverbial pot of gold, awaiting the other side of this deferred action rainbow. My second point is that DAPA violates the President's duty to take care that the laws be faithfully executed. Article 2 imposes a duty on the Constitution. DAPA violates its duty for three reasons. First, with DACA, the blueprint for DAPA, the administration limited officers to turn discretion to a rubber stamp. This reallocate resources to further transparent one at that. Second, because DAPA is not consistent with congressional policy, according to Justice Jackson's decision in the Steel Seizure case, presidential power is at its lowest ebb. Third, like the mythical phoenix, DACA and DAPA rose in the act of congressional defeat. The President instituted these policies after he voted down the legislation he wanted. Further, the President repeated over that he could not act unilaterally in the precise a violation of the Take Care Clause. Third and finally, while I support comprehensive immigration reform, the President's unconstitutional actions cannot be sanctioned. I hasten to add, if upheld, Democrats have much, much more to fear from this dangerous precedent. Generally, Democrats like when the government takes more action, and Republicans like when the government takes less action. Today, Democrats may approve of the President's decision to halt deportations, delay unpopular provisions of Obamacare, or not prosecute marijuana crimes. However, the situation would be very, very different if a Republican president declined to enforce provisions of the tax code, waive mandates under environmental laws, or declined to implement Obamacare altogether. In the words of James Madison, Federalist Number 51, the only way to keep the separation of powers in place is for ambition to counteract ambition. Although the courts play an essential role to serve as the bulwarks of a limited constitution, our republic cannot leave the all-important task of safeguarding freedom to the judiciary. To eliminate the dangers of non-enforcement, the Congress must counteract the President's ambition. The failure to do so here will continue the one-way ratchet towards executive supremacy and the dilution of the powers of the Congress and the sovereignty of the people. The rule of law and the Constitution itself are destined to fail if the separation of powers turn to mere parchment barriers that can be disregarded when the President deems a law broken. Thank you very much, and I welcome your questions.
All right.
Thank you.
Thank you. Thank you. Yeah, it was. I apologize. The audio is not very good. The hearing room itself is this humongous room. I'll give you a shot of the entire room, like there. It's this humongous room, and it's kind of cool. You stand up and you raise your hand and you go under oath, and then they give you 5 minutes to speak, and that's about it. And what you don't know is that there are all these cameramen sitting on the floor in front of you. You ever see that? It's actually kind of weird. They're like catchers in baseball. They're on their knees in the exact same position for 3 hours in a row. I don't know how they do it. It's remarkable. They're sitting there taking hundreds of pictures, which they try to sell to you later, which I didn't realize. But fortunately, the South Texas College of Law purchased a couple of them, so we have those here. I want to play one other clip. This one's short. So Representative Poe, who was actually not too far from here, gave a very nice shout out to our law school. So just listen to this, and I'll play it just for a minute. But he gave a very nice mention to our law school, so give you a little school pride. Second. This one will be short.
Kentucky's is too much. I go back to balance. I
Thank the gentleman from Tennessee. The chair will now recognize.
So I never play videos. It never works right, ever. Come on. Buffer. Go.
Gentleman from Texas.
I'm over here on the far right.
The Wi-Fi here is
Let me ask you some questions. Thank you all.
Second clip will take longer to load than to play.
For being here, Professor Blackman, thank you also for being here, South Texas. I couldn't get into South Texas, so but I'm glad you
Visit my classroom anytime, sir.
Tell Professor Treese hello. in our contemporaries. Quite a tribute to him, or credit to him. The school has him. That's just
Okay, that's all I want to play. So anyway, so we had a nice shout out in the congressional record. So go South Texas. Woo! We don't have a mascot, do we? Justice shall you pursue. Okay, so it was an interesting experiment. As I think I told you in the last class, the judge in Brownsville issued his ruling. Effective yesterday, the Department of Justice has appealed this to the Fifth Circuit Court of Appeals in New Orleans. Okay, so what happens next? So what's interesting is that there are two types of appeal. You may not even be familiar with these. There's a regular appeal where you don't agree with the judge, and there's something called a stay. What a stay is you're asking the Court of Appeals on an emergency basis to stop this ruling. In other words, the federal government saying, hey, you need to stop Judge Hanen's ruling in Brownsville, because if you don't, it'll be really bad. Okay? This is not saying that Judge Hanen was wrong. All it's saying is you need to stop him now while the appeal process winds its way. The difficulty for the government, though, is that to grant a stay, you can show what's called irreparable damage or irreparable injury. What does that mean, irreparable injury? They have to say, unless we implement DAPA now, there's going to be something really bad that will happen. That's a very hard argument to make, because the court may say, why don't you just wait 6 months for this to go? What's the rush, right? What's the urgent national security need? And this is going to be a serious burden for the DOJ. I don't think they're going to get a stay at the Fifth Circuit. I don't think the Supreme Court's going to grant a stay, especially because Judge Hanen's ruling didn't even address a constitutional issue. So this will go through the normal process, I think. I might be wrong. I'll tell you if I'm wrong in a week or two. And this might actually take another year and a half to wind its way to the Supreme Court, effectively running the clock out on the Obama administration. They'll be out of office by the time this is resolved. So this could potentially be the end of DAPA without much heavy lifting by any court, which I think was a serious lack of foresight and planning on the government, because they didn't expect the lawsuit. I don't think they did. Or if they did, they thought it would be like, some trivial things. So that's what's going to happen next with the immigration thing. So I don't expect this to be ending very well for the government. But again, I just testify on that behalf, so I have a small dog in that fight. So I'll do that with that caveat. Any questions on immigration? Yes, ma'am.
What's the significance when you say that the judge in Texas didn't rule on constitutional? I don't get.
So generally, a perfect segue to the decision today. Chief Justice Roberts, which you should know by now, did not invalidate the rule, the Obamacare rule, right? And a couple places the Chief Justice said, if there are two possible ways of reading a statute, one that finds it unconstitutional, and another that avoids finding it unconstitutional, courts should try to go to the way of not doing the constitutional route. The reason why is that a court invalidating a law is a serious act of striking down something that people's representatives voted. That's a very tall order. Something called a canon of avoidance. Anyone ever heard of this? This means if there's a concept, let's try to avoid it if we can. And in fact, this is exactly what the Chief Justice did in NFIB v. Sebelius. He avoided invalidating the mandate by construing it as a tax. So what Judge Hanen did was he basically signaled that this is probably unconstitutional, but I can find a narrow way of ruling this on various procedural grounds and administrative grounds. This is not going forward. Questionable whether this is a good idea, and I'm not particularly a big fan of this canon. I think it's unconstitutional. You should strike it down. But by doing so, what Judge Hanen basically said was, let the government first go through this administrative process. It might take 6 months or a year, and then we can decide if it's constitutional. But what we all know is that if they go through this process, you run at the clock in the administration, and they're out of office. And unless the next president decides to do the same, it's done. So there's a, I won't call it disingenuousness, but you could. But a slight tinge of, we know what's really going on here. I'm not going to strike this down, but I'm going to make it impossible for you to do this while you're in office. Have fun. Another example is a case called Shelby County v. Holder. I'm sorry, Shelby County v. Holder is a voting rights case from a couple years ago, where the Supreme Court invalidated different sections of the Voting Rights Act. And then the Supreme Court said, hey, Congress, you can go and fix the Voting Rights Act. No big deal, all right? Go fix it. Well, anyone who follows this knows there's a 0% chance that Congress will fix it. Zero, none. So basically, the court's striking something down, saying, "Hey, court, you can fix this in some other way. Go fix it," knowing they won't do it. Is that genuine? Is that actually acting in a restrained manner? Law professors don't necessarily agree on that, but it's a difficult question nonetheless. Okay. Any questions on immigration before I get started? Okay. So today the class will be a little bit different. I'm going to give you my normal Obamacare shtick, but I will break apart at various discussions to go through the case. This is a weird case for me because I'm so personally involved in it. Every time I read it, I'm still surprised by the ending. I know you probably don't believe me. I've read the case, I don't know, maybe 20 times at this point. Every time I read it, I'm still like, did this really happen? And if I can give a little backstory, if I may, I was not actually involved in this case. I was clerking while it was being decided, but I was writing, Jason, hold it up. I was writing a book as this was going on. Thank you. Very, very useful. So I had done interviews. I had spoken to just about everyone that you need to speak to. And I was actually scheduled to fly to London on the last day of the Supreme Court's term. Okay? So the Supreme Court releases decisions at 10 a.m. on a Thursday. And I knew this in advance. It was going to be the last day of the term. So I book a flight to leave to London from O'Hare, okay, Chicago O'Hare, at 10:30 Eastern time, right? 10:30. Okay, if you've ever been to O'Hare, flights don't take off on time, ever. Especially international flights. I think, okay, this is where I took off at 11 or 12, whatever, right? That'll give me enough time to download the opinion. I can read it on the plane, and that way I'll, some time quiet to read the entire opinion. Okay, so what happened in this case was not good. The Supreme Court released its first decision around 10:05. Didn't really care about that case. Another decision around 10:09. Didn't really care about that case. And then it was like 10:15, right? And at that point, the flight attendant had told us, "All right, everyone, please turn your phone off." And, oh crap, we're actually taking off on time. So of course I don't turn my phone off. And I'm thinking, oh God, okay. So my girlfriend was sending me giving me updates, and she's like, I don't know what's going on. The Supreme Court's website's down. Some people are reporting that it was upheld. Some people are reporting that it was invalid. What do you do? So the Supreme Court's website totally crashed. There was nothing on, and people were so confused. And I swear, at like 10:27, I have the G-chats timestamped. At like 10:27, she sent me a message saying, the Chief Justice voted to uphold the mandate. And that was the last message I had for 8 hours. I was in silence over the Atlantic for 8 hours. With only that, I was dying. I was dying. I was like, you gotta be kidding me. And that message came after wheels were up. I mean, I fortunately got that message. And when I landed, I must have like 150 emails in my inbox. I was like, what the hell happened? And I was totally jet lagged. I didn't sleep at all that night. I had a presentation the next morning. I stayed up all night reading this decision. Like, how did this happen? What in the world happened? I had to rewrite the end of my book. In fact, I'd actually, true story, I had told my agent to prepare two versions of the proposal, 2 versions, right? And I said, send this out the day the case is decided. Okay, one version of the proposal, the court invalidates it. The other one, they uphold it. But either way, it was a 5-4 normal, whatever, right? And I sent him this frantic email saying, don't send anything. I need to rewrite all of this. So the Chief Justice made by June of 2012 a very interesting period. I'm still not quite understanding what actually happened. But I will do my best to trace the chronology of this from the very beginning to the NFIB decision and to the present. And along the way, give you some cutting-edge knowledge of constitutional law about every single topic we've discussed in this unit. Commerce Clause, necessary and proper clause, taxing power, spending power, okay? This case has everything. Everything you can imagine, and really some more stuff that I didn't even anticipate. It was, in a word, unprecedented, which was the title of my book, and I didn't realize how good it was until this opinion came out. I had chosen that title a few month or two earlier. Anyway, that's not what I want to happen. Oh, come, what are you doing? Not cooperating with me today. Okay, let's try this. Oh, I know why. Sorry. There we go. Anyway, so let's talk about the Affordable Care Act. And I will use the phrase Obamacare, which people don't particularly like, but it's become effectively the known term for what the Affordable Care Act is called. In fact, President Obama was asked in an interview in July of 2012 in Rolling Stone, will you be happy if historians call this Obamacare? And he said, yes, it's my legacy. So I will respect the president's wishes and call this law Obamacare. So Obamacare represents a serious struggle between all branches of government in ways I don't think we've seen since the New Deal. You had the president who basically staked his administration on this. You want to ask why don't we have immigration reform? Obamacare. Basically, the first 4 years of his administration were entirely on Obamacare. No climate change, no immigration, nothing else. Even with that supermajority in Congress, the idea was do Obamacare and then worry about stuff later. So some people don't like that, but here we are. It was also a battle of Congress. In 2008, the president had a monumental election in which the Democrats sweep both houses of Congress. And the reason why this is relevant was they had 60 votes in the Senate. And with 60 votes in the Senate, they could basically pass whatever they want over a Republican filibuster. So there was a serious check that getting such a massive victory allowed. Okay? And of course, ultimately, the struggle went back to the United States Supreme Court and revolved around the meaning of the Constitution. Oh, by the way, so Representative Sheila Jackson Lee, I didn't correct her, but she said Section 2 instead of Article 2 of the Constitution. I didn't have it in me to correct her, but she did. I know, but she did whip out a pocket Constitution. So I was like, okay, that's good enough. But then she called it Section 2. I'm like, all right, I'll let that one slide. Yeah, always have one at hand. You never know when it'll come in handy, right? So health insurance and healthcare in America has been a long-running topic of controversy. It's an expensive aspect of our society, and there have been many efforts to try to fix it, one of which was with President Clinton's lady, Hillary Clinton. In the early Clinton years, they tried to enact what was known as the Health Security Act. The Health Security Card. If you go to the Clinton Presidential Library, show card there, behind glass. I took a picture of it somewhere. So what was the Health Security Act? It was more or less a single-payer healthcare system, more or less, with some nuances. In other words, we get this card, which you give them some sort of health insurance, pay for part of it. It was this humongous attempt to reform health insurance to bring us in line with some other Western countries that have these systems in place. Did it pass? No. So there were very famous series of commercials. I don't know if anyone remembers these. The Harry and Louise commercials, where this husband and wife, a ma and pa, sitting around a kitchen table saying, I don't know, I like my doctor, I want to keep my doctor, I don't want this government healthcare plan. Remember, we'll come back to that later. And these commercials were so effective, they basically killed the Clinton healthcare law. Never made it. And in fact, that was in part why the Republicans took the House in '94. That along with the gun control law, which we discussed with Lopez last week. So as it stood, the United States had no real healthcare reform until the inauguration of President Obama in 2009. By the way, President Obama shares a record with FDR. The record is he's the only person to take the oath of office 4 times. Anyone want to know why I took it 4 times? Anybody know this? What? Okay, so the first time in 2009, I remember I was listening to it on the radio live. The Chief Justice and the President were not on the same page. So when you say repeat after me, you say some words, you stop, and the person repeats those, right? But it's very important where you break. So what happened was the chief had different breaks than the president. So the Chief Justice said, he read a few words. The president cut him off because he thought he was going to break somewhere else. So the president memorized it. So they were talking over each other. In fairness to the Chief Justice had sent a memo to the president with the exact paragraph breaks of where he'll stop reading, and that never got to Obama. But, it happens, right? So lest there be any doubts, they did it over again the next day in the White House. Just in case anyone says he was never sworn to office, they did the oath one more time. Fast forward to 2013, right? Constitution says inauguration's on January 20th. January 20th was a Sunday. You can't hold inauguration on a Sunday, right? So they held a private one in the White House, and they held a public one outside. So he's actually had the oath of office 4 times. Still, I'm sure some people say he's already term limited after 2, but you know, he did the oath. He's 4 times, so term limits are applicable. Okay. And the president made his primary accomplishment, his primary legislative goal in his first term of office was the patient protection and a PPACA. Although no one talks about the patient protection word, that's gone. It's only ACA, Affordable Care Act, or as we humbly know it now, Obamacare. Okay. The question, though, about Obamacare, is it constitutional? Okay. And I need to give you some backdrops of the politics, because this case teaches you not just about the Constitution, which I hold dearly in my pocket, right? It also speaks to something called social movements, right? So throughout American history, they have tried to accomplish change by looking to the Constitution, the Declaration of Independence, for a higher power. So one of the first examples were abolitionists, right? Frederick Douglass, among others. He said, look, you have this Declaration of Independence saying all men are equal. You have this Constitution that doesn't even use the word slave, right? There is nothing in the Constitution that allows slavery. Whether the argument's right or wrong, you know, we can argue as a matter of history. But when you make these arguments appealing to the Constitution, they take a much higher salience. Same thing, the suffragists, women who wanted the right to vote. Susan B. Anthony said, equal protection says for all people. It doesn't say all men. Give me a voting card. And actually, Susan B. Anthony persuaded someone to give her a voting card because, as she said, all men are, all people are equal, right? It says all persons in the 14th Amendment. The Civil Rights era, they look to the 14th Amendment saying segregation is not equal. You can't have segregated schools. So that in American history, there have been various social movements that look to the Constitution to give extra oomph to their arguments. And in 2010, a group popped up seemingly out of nowhere, the Tea Party. And they actually sprang up not in 2010, really in 2008 towards the end of the Bush administration, but they really got going after the election. Their rallying cry became Obamacare. They said, Obamacare is unconstitutional, right? Because don't tread on me. And against the backdrop of the legislative debates over Obamacare was this group that started off fairly small, saying hell no to Obamacare, growing bigger with marches on Washington, and then growing to the tens of thousands with marches and rallies nationwide. I don't know if any of you remember the period of 2009 or 2010 if you were there, but there were significant rallies and marches across the country. On the day Obamacare passed the House, I happened to be in Washington, D.C. I wasn't actually attending the rally, but I was walking around taking pictures. I saw John Voight, you know, whatever, right? And George Costanza owned his car, I suppose. So I was one. So I was there, right? And holding up signs. And what do these signs say? I swear to God, overturn Wickard v. Filburn. You had a guy with a sign saying overturn Wickard v. Filburn. So when you have these arguments that aren't just saying, you know, get your damn hands off my government health care, right? Get your damn hands off my Medicaid. They were actually arguing we need to restore the Constitution. That gives this movement a different level of relevance than others. But all their efforts to try to stop Obamacare were not going to win because, again, the Democrats had 60 votes in the Senate. Okay? And Harry Reid, who was was not going to take a black eye on this and was destined and committed to making sure that this bill passes. So here we have it. This is the Patient Protection and Affordable Care Act. Does anyone know how many pages the bill is? About 3,000. Okay. I like the visual so you can see roughly how tall it is. The bill in its final form was released December 12th, 2009. Might be off by a couple of days. And the idea was this is only a draft version of the bill. This is not the final version of the bill. Let's get a vote on the record in the Senate so all of our members can go home and say, look what we did over your Christmas break. We did this awesome Obamacare bill, right? The idea was pass this Senate bill, send it over to the House of Representatives, right? The House will make some changes, send it back to the Senate, make some more changes, and go back and forth, you know, and actually work as a government should, and make this bill perfect. You know, iron out all the kinks, get rid of all the bugs and errors, right? So very quickly, without too much debate, the final version of the bill was voted on December 24th, 2009, Christmas Eve. This was the first time, I did the math, over 100 years, this relevant to the bill? Well, at the time they said, who cares? This is not the final version. We can fix it later. We can work in the House, iron out all the kinks. But as it turns out, the Obamacare bill that no one read in December of 2009. Why is this even more relevant? Because next Wednesday, I'll be back in Washington, D.C. for another Supreme Court case, the decision of King v. Burwell. Okay? I don't want to go too far into it, but King v. Burwell involves subsidies for Obamacare. So the statute says, and this is its text, if you live in a state that established an exchange, you get various subsidies to make your health insurance cheaper. Okay, what happens if you live in a state like Texas that never bothered establishing exchange? Well, the federal government said, well, state exchange is the same thing as a federal exchange. There's no difference. Okay, I'll talk about that next week after I get back from the arguments. But what I want you to learn about now is this is a phrase that very likely would have been picked up and corrected had the bill went through the normal process. But because the version we have now was this draft version, the Supreme Court stuck with interpreting an incomplete bill. Okay? Why did they never have the opportunity to fix the bill? Ted Kennedy. Right? Senator Ted Kennedy from Massachusetts died in the summer of 2009. He was the 60th vote in the Senate. Once Ted Kennedy died, the Democrats didn't have 60 votes. So the governor of Massachusetts made a temporary appointment. I can't remember the guy's name, wasn't too important. But he was there long enough to vote on this December 24th bill. But in January of 2010, Massachusetts, no right-wing state, this is not Mississippi, held a special election to determine who will fill Ted Kennedy's seat. Who won? Scott Brown, a Republican. And let me put a finer point on this. A Republican won in Massachusetts to replace Ted Kennedy on the promise of stopping Obamacare. He ran as the 41st vote. That was his platform. He said, I will stop Obamacare if you vote for me. It's remarkable that Massachusetts even voted for Republican. I mean, he lost re-election last year to Elizabeth Warren, but he actually got put in for the sole purpose of stopping Obamacare. Okay? So once he was elected, the Democrats were in trouble. Right? Why were they in trouble? They only had 59 votes. They only had 59 votes. Any bill sent back to the Senate would be filibustered and killed. Done. Would have been dead on arrival. So what happened? They still had the December 24th vote. They still had the draft bill passed on Christmas Eve. That will become the Affordable Care Act. This draft bill that no one read, that no one cares about. So one of the reasons why I still get so angry about this entire topic, and this is a little more personal, is because we're dealing with a draft bill that no one ever wants to be final. And various administrative agencies are treating this as if it's some sort of like God-given law, when it was actually an incomplete version that due to Ted Kennedy's death we're stuck with. But that's neither here nor there for a moment. It actually will matter much more for King v. Burwell. Okay? So what happened? The House of Representatives or Speaker Pelosi said, okay, we can make this work. All right? But there was a problem, said John Boehner, who was then the House Majority Leader, between the Republicans and Democrats. Here's another good shot for scale, see how big the bill is, right? There were many aspects of the Senate bill the House didn't like. Okay? So generally, when there's some aspects that one House doesn't like, they cut them out and they send it back to the Senate, they make some changes, you go back and forth. The House could not make any changes. Right? Why? Once the House made a single change of any substance, the Senate will have to take another vote. And once the Senate takes another vote, filibuster, dead, done. So this House was forced to vote on a bill that they couldn't change. Police debated this and the House debated that, whatever. They couldn't change anything. They were stuck. They were stuck. So Speaker Pelosi had this great idea, right? They said, here's what we're going to do, right? We're going to use this process called reconciliation, okay? So we're not actually going to vote on the bill that the Senate passed. We'll vote on a version of it. And then we'll send that back to the Senate through this budget reconciliation process, which only requires 50 votes. So generally speaking, when one house passes the budget, minor changes can be made in the other house, and there's only a 50-vote block for a budget, okay? This is meant for things like tax reform. But the House adopted this reconciliation method to make changes to a bill that would not be voted on by the full Senate. So by using this reconciliation process, they're able to make changes to this bill, not nearly enough as they should have, and then send it back to the House, send it back to the Senate with no filibuster, okay? This was very, very rogue. It's unclear if parliamentary procedure even allow this, but this bill, excuse me, had to be passed. They had to do it. So the House brought up for a vote. I want to draw your attention to one number. There's a big 0 there, okay? Not a single Republican voted for the Affordable Care Act. So as a point of history, every major civil rights legislation or health legislation in the 20th century was voted on a bipartisan basis. Social Security, Medicare, Medicaid, Civil Rights Act, Americans Disability Act, right? Every single piece of major legislation in American, at least the 20th century, was a bipartisan bill. Here, there was no Republican support. Now, there are two ways of looking at this, right? And I'll give both sides. One way is Republicans simply wanted this to fail. They had no interest in the president succeeding in having this law. The other position is that half the country didn't support this law. And the numbers actually somewhat support that the Affordable Care Act has never gone above 50% popularity. And in wide swaths of the country, people simply don't want it. A study was done in 2008 where they said, are you happy with your health insurance? And about 80% of the people said, yeah, I'm happy. 20% probably were very unhappy, but for the most part, people were okay with their health insurance. The Affordable Care Act was sold as a way to make healthcare more affordable, which is not really the case. It's mostly redistribution. It makes health insurance affordable for people who are sick or old. I mean, that's a laudable goal, but that's not exactly how the law was sold, okay? But the fact is, the reason why people continue to vote to repeal it is they want nothing to do with it. And the fact they want nothing to do with it stems from that goose egg right there. And that not a single Republican has ever voted for anything about the Affordable Care Act. And they say it's Obama's problem. I don't think that will last long. I think that'll have to fade eventually. I also want to draw a note to this. 34 Democrats voted against the bill. This wasn't even that popular among Democrats, right? There was severe defection. So the final vote was 219 to 210. The vote was probably a little bit more of a padded, but the Democrats let a few votes go away, just they had people can go home to their moderate districts. But with this, the bill had passed the Senate. Slightly different bill passed the House. Reconciliation, the Senate passed it. And we now have the president's signing ceremony, okay? So the president signed it, and he made some remarks a couple of days later where he said, this was when March 23rd, 2010, if I might be off by a day or two. The president said, the battle over healthcare reform is over. March 2010, the battle over healthcare reform is over. We won. He did not get that one right. The battle was only just getting started over Obamacare. Specifically, the first round, and actually by my count, we're now in round 3. First one was NFIB, then Hobby Lobby, and now King v. Burrow. There's at least a third round at the Supreme Court. There will be others, okay? But round 1 began with the constitutional challenge, right? Was Obamacare constitutional? So if I may give you a brief introduction of how Obamacare actually works. Now, some of you may have purchased it or know about it or whatever it is, but let me give the general idea. A lot of you in this room are young and healthy, and you maybe perhaps don't need health insurance, don't want health insurance, but eventually you'll become old and sick. It's an unavoidable fact of life. The only thing is certain in life are death and taxes, both of which are covered by Obamacare now. So the Chief Justice makes that joke in his opinion, so I didn't exactly make it up, but it works. So a number of states said, you know what? It's not fair. It's not fair that health insurance companies charge so much money to people who are sick with various pre-existing conditions, right? Let's require all insurance companies in our state to, fix the prices based on people on age, right? They can't charge more for people who are sick. Okay, that sounds like an awesome humanitarian goal, but there's an economic problem there, right? If I know that the insurance company can't charge me more if I'm sick, why don't I just not buy insurance? And if I get sick, I'll buy insurance. Order some up on my iPhone on the way to the hospital, right? Wait till I'm sick. Doesn't exactly work like that, but wait till I'm sick and then buy at the next open enrollment, right? Buy insurance then. People aren't stupid, and they started doing this. So places like Massachusetts, New York, and elsewhere, insurance premiums went through the roof, right? Why? Because the insurance companies knew all these people are waiting to buy health insurance while they're sick. Let's charge more to the people who are already in the market. Let's take more money from them. This creates something known as an adverse selection death spiral. Because as fewer people pay into the system, rates go up. And when rates go up, people cancel their policy. It's too expensive. So fewer and fewer people pay into the system. There's less money. The sick people stay, and the rates go through the roof. This represents a significant problem for health insurance. So what's the idea? We require people to buy health insurance. We require them to buy health insurance. That way, when they get sick, they're covered. And if they are not sick, they're still paying into the system, right? They're still paying money into the system to spread the cost of insurance. Okay. So the first state to do this was Massachusetts, led by Governor Mitt Romney, of course, the Godfather of Obamacare. So actually responsible for imposing a mandate on the people in Massachusetts, and this was cheered on by Ted Kennedy and Jonathan Gruber and all our people who we know all too well today. So this was actually something of a conservative idea. Conservative free market said, rather than having single payer, let's require people to take responsibility, buy some minimum level insurance, pay into the system, and make costs less for everyone else. Okay. Now, can a state require that you buy health insurance? We've discussed the state police power, right? And generally speaking, the state police power is very broad. They can mandate you go to school. They can mandate you get vaccinations. They can require that you do a lot of stuff. Right? They can make you buy car insurance if you're driving, right? Only if you're driving, though, not if you're a non-driver. I'll stress that point later. But can Congress require you to buy health insurance? Now, if this was a constitutional law class in 2009, that's what the year I graduated law school, and if someone had asked me, can Congress pass a law requiring Americans to buy health insurance if they can afford it, if they have above a minimum income level, right? If you had asked me, Josh, is that constitutional? I said, yeah, why not? That actually happened. So this is a good story. In November of 2009, the Federal Society, which is a national group of conservative lawyers, had their annual meeting in Washington, D.C. And if you imagine the right-wing conspiracy, this is where it meets. So there was a gathering of lawyers. I was among them in the hallway. And we're discussing there's this new healthcare law that's coming down the pipe, right? So someone says, well, what if the government, made you buy a gym membership or made you buy Brussels sprouts or something? I don't know. Why can't they do that? It didn't occur to me. So someone said, Josh, you're a bright young guy. Can you write something for me about this? I'm like, I'm clerking now. I can't do it. So they found someone else, fortunately, who could do it. And in a very brief period of time, they came up with this argument about why Obamacare is unconstitutional. But when I say this, I mean it. This argument did not exist before 2009. The argument about why Obamacare was unconstitutional was invented in the months leading up to its enactment. This was a remarkably fast turn of constitutional law. That, I should stress, took most law professors by surprise. In fact, most law professors still think it's a stupid argument. I don't agree with them, but they think this argument is ridiculous because it came out of nowhere. It came out of, not left, right field, I guess, right? So let's take a brief walk down memory lane, and let's discuss our precedents concerning the Commerce Clause. This will be a nice review for you, if you will. So before the New Deal, you may recall the Supreme Court was all over the place. They tried to craft different things about what is and is not commerce. That, manufacturing's not commerce, but railroads are, and they had all these various confusing precedents. But we get to 1941 after the New Deal, and with the case of Wickard v. Filburn, right? In this case, the Supreme Court held that even if you have purely intrastate activity, the farmer growing his wheat on the farm, if in the aggregate this activity has a substantial effect on interstate commerce, Congress can regulate it. That if the farmer's activity of growing wheat in the aggregate, if there are a lot of farmers doing the same thing, affected market prices, then that's sufficient for Congress to regulate it. Wickard was the furthest reaching stretch ever of commerce power. And it gave them a serious reach over the Commerce Clause. I love this cartoon. Okay? Exactly. You ever see the Family Guy episode where the right to bear arms is actually like bear's arms? Yeah, you can Google that later. So we have Wickard. But then we have some cases in the 90s which went a little bit away, right? We had Lopez. This was a gun-free school zone case. And the court said the mere possession of a gun is not an economic activity. And because Congress hasn't had findings or a jurisdictional hook, but why this is interstate commerce, Congress can't criminalize the possession of a gun in a school zone. And then we had the case about 5 years after that, United States versus Morrison, right? The court said domestic violence is not an economic activity. As terrible as beating someone up is, that's not economic activity, and that's something within the police power of the state to regulate, right? So at that point, we had this pushback, right? So things that weren't economic activity, were outside the scope. That brings us to the case of Gonzalez versus Raich, not Terry Schiavo, right? Gonzalez was Raich was this, she had various tumors, very sick in California. And she argued that, her local grown marijuana, but the local Whole Foods, was only slightly exaggerating. So her locally grown marijuana was not interstate commerce, right? Because it never crossed the state line. And there is no interstate marijuana market the same way that there is for this in an opinion based on both commerce, necessary, and proper. So first, the court effectively said that, well, it is purely interstate. There's never necessary and proper incident to that. Please, they need to. If you allow people to grow pot locally, the federal government's plans to stop this interstate trade of pot will fail. So although it was a commerce decision, it was really more of a necessary and proper decision. I think it's a better way to understand Raich, right? In order to actually police the drug crimes, you need to be able to stop this locally grown marijuana, even if it's only within one state. So this case was argued by my good friend Randy Barnett, who wrote the foreword to my book. And if you want to read it, I think the bookstore has a copy or two left, or it's on Amazon for much cheaper. It's like $5 on Amazon if you want to buy it. It's really cheap. Bargain based and stuff. It's like a Kmart level, right? Raich lost. Okay, so we ask ourselves, we have Wickard, we have Lopez, we have Morrison, we have Raich. What's the problem with the federal government requiring you to buy health insurance? Right? Why is that constitutionally suspect? Right? Why is that in doubt? Certainly, health insurance is some sort of economic behavior, right? Buying something, paying for something, isn't that economic? Isn't that commerce? Right? Can Congress regulate this? So this is where law school as a thinking exercise becomes important. All too often, people think of law school as a way to prepare for the bar and learn whatever the black letter law is, and that makes me hurt a little bit on the inside. I mean, it's a fair point. But there are certain skills that you learn in law school that go far beyond passing the bar, which is the first thing you'll ever have to do, but not the last. And that train you of how to think of things differently. Okay? So here's what happened. If you go back and you reread Wickard and Lopez and Raich, you'll notice something. You'll notice that whenever the court speaks of the Commerce Clause, they always speak of economic activity or classes of activity. If you go back and you can highlight, almost every single time they speak of economic activity, right? Congress is regulating Phil Burns' growing of wheat. That's some sort of economic. Congress is regulating Angel Raich's purchase of marijuana. That was economic activity. The gun in the school zone was not economic activity. The court said that. Having guns not economic activity, just possessing it. Domestic violence against women. The court said that's not economic activity. You're sensing a pattern here, right? In cases where there's some economic activity, the Supreme Court upheld the law. In the two cases, Lopez and Morrison, where there was no economic activity, the laws were invalidated. I didn't read the cases this way, but once my good friend Randy Barnett and a few other people put out a paper explaining it in this manner, I had a eureka moment. The Supreme Court, in every single case, has said you can regulate classes of activity. Is that regulating an activity of health insurance? This is where you turn everything on its head. The argument goes like this. The individual mandate is not regulating economic activity. It's regulating economic inactivity. The way, and this is the argument, I'm not necessarily endorsing it, but the way this argument goes is that the Obamacare mandate is not regulating some sort of pre-existing economic activity, like growing wheat or growing marijuana. It's regulating economic inactivity. Your decision not to buy health insurance. This is one of those oh my moments, right? Before, it's like, those 3D paintings, right? When you look at them, you see a bunch of dots, and you bring it closer, and the thing jumps out at you. I had one of those moments. It's like, oh my, it's right there in the Supreme Court's decisions. In bold letters, go back into your notes. I'm sure you can find it. Justice Scalia's concurring opinion, Raich and Lopez and Morrison. It always speaks of activity. So the argument was developed. The fact that Congress can regulate economic activity presupposes that activity exists. What do I mean by that? Anytime the court's regulating activity, there was some activity before. What does the mandate do, according to this argument? It forces you in to economic activity. It requires that you buy insurance, requires that you engage in a commercial transaction. And by making you buy something, by making you buy insurance, they've just thrown you into the stream of commerce. Remember that phrase from Cifro, stream of commerce? Asahi? This is where it comes from, by the way, if you were curious, right? They've basically thrown you into the stream of commerce, or you're drowning. I see you swimming around, flailing. Grab onto a tire or something, I don't know. Hopefully it doesn't pop. So, that's good, actually. I haven't thought about that case in a while. So, the question was, can Congress make you buy health insurance? Can they make you enter economic activity? Because once you're engaging in economic activity, they can criminalize possession of marijuana. They can fine Phil Burns for growing too much wheat. Everyone get the general gist, right? This is an idea of constitutional law that didn't exist before 2009, but it's now one of the most important decisions of the 21st century, and probably both centuries, if I had to guess. All right. So everyone get the general gist. Any questions? Stop me. I'm lecturing today more because it's my usual shtick, but stop me. Yeah.
Just from a purely logical standpoint, don't you argue that the choice to be inactive is in itself an activity?
That's what the government argued. We'll get to that later. Okay, I'm not telling you necessarily what's right. I'm trying. That's exactly what the Solicitor General argued. Any other questions?
Black people stay in hotels, so isn't it the same thing? Like, you're not.
But they had a hotel. Wasn't running a hotel economic activity. You see, it's a very, and your instincts are exactly right. The arguments that you two made were the exact arguments law professors made. How can you say this, right? But the challenger said, listen, you opened a hotel, you opened a restaurant, right? You had a farm, you planting crops, like you were cultivating marijuana, right? Hector?
I think you pretty much covered.
Okay, good. So the enduring symbol of this case became a crown of broccoli. I briefly flirted with making the cover of my book a piece of broccoli. I got rid of that idea in like a day. But if you, I actually mocked it up myself. With a picture of the Supreme Court with a piece of broccoli on it. I'm glad I didn't go with that. But I thought about that for about a day. I actually made up the mocks. So why broccoli, right? So the argument goes like this. If Congress can make you buy health insurance, right, in order to improve the health insurance marketplace, why can't they make you buy broccoli? Broccoli is healthy, makes you healthier, might lower your cholesterol, you'll need less health insurance costs. This is what's often known in common parlance as a slippery slope, right? If the government can do X, why can't they do Y? But I want to give it a better name, which is called limiting principle. If the government can make you buy health insurance, what's the limiting principle of going further, right? Why can't they make you buy broccoli? So rather than just saying the slope is slippery, it's like, what is your distinction, right? Why can they make you buy this but not this? Once you accept the purchase mandate, right? And broccoli has taken on a salience of massive popular support. There's actually an episode of The Simpsons, I love this one, where the president was making the dog eat broccoli, didn't want it. But let's think about this for a moment, because actually Justice Ginsburg and the Chief Justice debate over this in their decision, right? So the Chief Justice says, why can't the government make you buy vegetables? It'll make you healthier. You don't have to actually eat it. They have to make you buy it in hopes you actually use it. Similarly, the Congress can't make you use the health insurance, but they can make you buy it. Okay. What about a GM vehicle, right? At the time, General Motors was in the receivership of the United States government. We were all owners. You may not have known that. We were the owners of General Motors vehicles, right? Why couldn't the government say, okay, for your next car, you have to buy a GM vehicle, and if you don't, we'll make you pay a penalty. We need to support Detroit, right? Bring back Detroit. So these were the constitutional issues that are percolating. And it's still surreal for me to talk about this if it was history, because I was there in the middle of it. But this is now something which is in your books. It's actually printed, and I know it happened because it's in print. I'm still surprised by it every time I read it. So that's right, May 23rd, 2010. So we go back to the law. The president signs it, approved. The lawsuits begin. Before the ink was even dry. And by the way, the president uses 23 different pens to sign a signature. That way, he can hand the pens out as like gifts, commemorative, send some to the museum. So he writes a little bit, he's a lefty, so he writes a little bit of signature at a time with each pen. So part of the O, then like the B, right? And he gives all these as presents. It's a cool tradition, right? But if you notice, the signature is very choppy. So the O is not very good. It's not very round because he's like 4 different. You can actually see like 1, 2, 3, 4, 5, 6, 7, 8. You actually see the 8 different pen strokes that were made for the O. Anyway, apparently he's actually practiced this. He's gotten better. I've read. So he won't be doing much more signing other than the veto pen for the next 2 years. But at least that's some practice, right? So the lawsuits were filed within minutes. Within minutes. And who was filing? States. So one of the interesting aspects I've discussed is Texas litigation is you have 26, virtually all red states, challenging the president's actions, right? The virtually same thing happened 4 years earlier with Obamacare, where you had, initially it was 13, but it went up to 26 or 27 states challenging Obamacare, okay? So the first lawsuit was filed by alum of my law school, the Attorney General of Virginia at the time, Ken Cuccinelli. He ran for governor unsuccessfully and lost to Terry McAuliffe last year, or 2 years ago, can't remember now. And Cuccinelli argued for Virginia that the individual mandate was unconstitutional, okay? It's very hard for me to tell you how much law professors hated this argument, okay? It's very hard for me to explain to you. Almost every single law professor in the country, without a doubt, said these arguments were stupid and that any lawyer who signs his complaint should be subject to Rule 11 sanctions. I'm not joking. They said any lawyer who puts their name to this should be sanctioned. So I want to explain why this is important. And this is not just for law professors. When there's a new idea that people disagree with, the first reaction is to call it stupid and bad, right, and vilify it. But by doing so and not engaging on the merits, they let the other side build up steam. And they let the other side make arguments that are not getting rebutted. And virtually every single newspaper article about this, any professor quoted said, oh, this argument's stupid, ridiculous, sanctionable, right? And the people on the other side said, oh, here's the Commerce Clause, here's Wickard, right? It says activity. So if there's an idea you don't like, don't call it stupid, okay? One of the first decisions was by a judge named Fred Vinson. I'm sorry, Fred Vinson, right? Oh, Roger Vinson, I'm sorry. A professor, either Harvard or Yale, said the judge should have been named Roger Taney, right? Professors actually compared these decisions to Dred Scott, saying these are worse than Dred Scott. Okay, I mean, that's just insulting, but wrong, because there's actually precedent supporting this. Anyway, the first judge to rule was Judge Hudson in Virginia, and he ruled against the administration, okay? At this point, the argument becomes real. This is not just a law professor on a blog writing a post explaining why Congress can't regulate an activity. You now have a federal judge nominated by the president, went through the Senate, accepting this argument. This argument was now on the wall, okay? But the main event wasn't Virginia. The main event was in Florida. This is Judge Vinson, who was a Reagan appointee. And his case was brought by the state of Florida. And Florida was joined by a group called the NFIB and a few individuals. So this is where it gets important, okay? There were two main aspects of Florida's challenge. So the individuals, the National Federation of Independent Business, these are small business owners, they challenged the individual mandate. They argued that they did not want to buy insurance and that this requirement to buy insurance was unconstitutional. As individuals, the mandate acts on them. The mandate does not act on the state. Okay, this is a very important point. The state of Florida has no interest in the individual mandate. They can't stop it. What did Florida challenge? Florida challenged a second aspect of the law, which is the Medicaid expansion. Okay, so let me explain a little bit how this works. You have Medicare and Medicaid. You may not know the difference. Medicare is for old people. Remember, R, retired, right? It's people above the age of 65. So once you hit 65, mazel tov, if you're on Medicare, you can't get private insurance anymore. Have fun, right? Medicaid is meant for people who are poor, at the poverty line. And historically, people who were eligible for Medicaid were at the federal poverty line, whatever it is, and it changes every year, or whatever, right? What Obamacare said was the poverty line isn't high enough. We need more people who are poor on this. So Obamacare said to the states, all right, raise your eligibility for Medicaid in your state budgets to 133% of the poverty line. So now people who are above the poverty line are eligible for Medicaid. And the federal government said, you know what? We're going to pay for all this for at least next, several years, right? It won't cost you much. There'll be some cost to the state, but not much. Oh, and by the way, here are all these new conditions that you have to follow. You have to do this and do this and do this, and But hey, if you want our money, right? No free lunch. Take it. Okay. So Florida challenged this. under a case we did last week, South Dakota v. Dole. Florida said that this is coercive. Right? Why is it coercive? Now, this is where it gets interesting, and most people didn't pay attention to this aspect of the case, myself included. Okay? In South Dakota v. Dole, South Dakota stand to lose 5% of their highway budget. We're not talking a lot of money here. It's a very small amount of money. And the Supreme Court said that, look, they have the choice. They can decline to take this money. Keep your drinking age at 18 or 19, whatever it was. Obamacare works differently. So in the fall of 2009, Arizona Governor Jan Brewer sends a letter to the federal government and says, hey, guys, right? What happens if we don't expand Medicaid, right? What if we, just keep it as we are now? Can we keep our existing money? And in a letter that haunted the United States until the Davis case was decided, some low-level wonk wrote back and said, Arizona, get this. If you don't expand to 133% of the poverty line, you lose your entire budget. You lose your entire Medicaid budget. Not only will we not give you the new money, we will take away all of your old money. We'll bankrupt you. You'll now have millions of people who can't afford insurance. Have fun. Good luck. Do it yourself. So the question in this case was there a choice? Was this persuasion? Or was this coercion? Could the states meaningfully decline to turn down this money? Okay. So I'll start by noting that until the Supreme Court, not a single judge in the United States found that the Medicaid expansion violated the South Dakota v. Dole principle. The first court to find a constitutional violation was the Supreme Court. But for now, at least the next 20 minutes or so, I will only talk about the individual mandate. Okay? Judge Vinson, in a lengthy opinion that reminds me of Judge Hayden's decision in many respects, said the individual mandate is unconstitutional. It's void. Congress cannot regulate an activity. Congress cannot compel you to eat broccoli. It's actually funny. The first remark I tracked this down was not broccoli, but Brussels sprouts. Judge Vinson asked, can the government make you buy Brussels sprouts? So it wasn't actually broccoli initially, but became broccoli. Okay. So here, the president lost. And at this point, you had 2 federal district courts who found Obamacare was unconstitutional. Many others upheld them, right? That's not what we were interested in. It's how many judges would invalidate them. And I should pause to note that all the judges who voted at this point to invalidate the laws were from Republican presidents. And virtually all the judges who upheld it were from Democrat-appointed presidents. We could discuss later the salient to that, but it did weigh, I'm sure, on the president's mind. So at this point, we go to the Courts of Appeals, okay? And we had a series of arguments between Neil Katyal, who was the acting Solicitor General, and Paul Clement, who's the Ubermensch, who's one of the top Republican lawyers in the country, who argues all the big cases. So the first case was argued in the Sixth Circuit Court of Appeals, where I clerked. I got there probably 2 months after the case was decided, so I had no involvement with it, probably for the better. And in this case, Judge Jeff Sutton, who is a George W. Bush appointee, voted to uphold Obamacare. And this was considered very significant because now you had a Republican-appointed judge, very conservative, well-respected, saying the court should not strike down this bill, should not strike down this law. So this is my happy Obama picture. He's really happy there. Yeah, held up. Okay. But the main event was in the Court of Appeals, the 11th Circuit in Atlanta. Right. This was appeal coming up from the Florida case. The 11th Circuit is Georgia, Florida, and Alabama. Right. So this case, though, took a very different turn. In a majority opinion by Judge Frank Hull, Frank's a male, and Judge Joel Dubina, the 11th Circuit invalidated the individual mandate. They found that the mandate was unconstitutional. Okay, why was this so significant? Because now we had a circuit split. You had the 6th Circuit going one way, you had the 11th Circuit going another way. This basically required that the Supreme Court take the case. I think I blogged at the time. I didn't think the Supreme Court would take the case. One of my wrong New Year's resolutions for 2010 was the Supreme Court would never take this case. I was wrong. Or was it 2009? I can't remember. Anyway, I think in 2009 I wrote a list of predictions for the new year. I said Supreme Court will never take this case. I don't make predictions anymore. So I don't. So after this point, the president was not happy, okay, because now we had a circuit split. The next decision was the decision from the Fourth Circuit in Richmond, Virginia. Okay, and I need to bore you with tax law for a moment. I promise it'll be brief and painless. Okay, unfortunately, your book cuts out the section on the Anti-Injunction Act, but which is a mistake because this was the most important aspect of the case, which no one even cares about. So we're now in the end of February. I hope all of you are filing your taxes soon, and if you're not, get an extension because you will be in trouble. But generally speaking, when the government says you have to pay a tax, you have one option. Pay it, right? If you don't pay it, they'll hit you with penalties and fines and lock you up like Wesley Snipes, right? You'll be in trouble. But what happens if, say, the tax was incorrectly assessed? Maybe you had some disagreement about how a deduction should work, whatever, right? So the general way the law works is you pay the tax and then you sue for a refund, right? You pay the tax first, then you go to court, you sue for a refund. This law makes a lot of sense because if people could just sue right away, no one would ever pay their taxes. People would just go to court all day. So this law is called the Anti-Injunction Act. What the Anti-Injunction Act does is it says you can't go to court until you've paid your taxes. All right, everyone get that? So all along I've been talking about the mandate as a regulation of commerce. In fact, that's how Congress designed it. In its constitutional findings, Congress said that the individual mandate is justified by the commerce power. But the government raised another argument fairly early on. They said that the Obamacare mandate is actually a tax. So the way it works is if you don't buy insurance, you pay a tax, right? And because the tax would not be assessed until 2014, no one paid the tax yet. Therefore, the suit is not yet ripe. You can't bring it. Everyone get that point, right? The Obamacare tax doesn't cut until 2014. Now, right? Therefore, who's going to sue on it in 2010? But there's a problem with this argument. The problem is, in the statute, it's labeled a penalty. Congress went out of its way to call it a penalty. The President of the United States, on This Week with George Stephanopoulos, was asked, is this a tax? He said, no, it's not a tax increase. Why did the President say that? Well, because taxes are unpopular. He just ran on a pledge of not raising taxes. So virtually every single member of Congress said, this is not a tax, this is not a tax, this is not a tax, this is not a tax. The second this case went to federal court, oh, this is a tax. So yesterday during the hearing, I brought up the fact that many times the president had said that he lacks the power to suspend the deportations of millions. And one of the Democrats said, well, this is all just political theater. And I replied saying, with respect, it's not. But when the president makes statements about what his view of the law is and then suddenly changes them, it speaks to his good faith intentions. But more importantly, when the president says something, people rely on it. When members of Congress hear the president say something, they rely on it. When members of Congress vote on this bill, they said, okay, we're voting this as a penalty, because if we vote this as a tax, it'll be unpopular and may lose some credibility. It frustrates me to no end when the government changes positions after the law is passed, saying, oh, it was actually a tax, or oh, the president has his power, right? Because they're basically changing the legislative bargain, that people vote on something under one understanding and they're defending on a totally different one. Okay? This was not a tax. In the constitutional findings of this law, the taxing power is not even mentioned once. This was meant as a regulation of interstate commerce. And you will not find a single shred of evidence. I've had this argument with people who worked in the Obama administration that I said, show me one thing, one public statement that this was a tax. Like, oh, no, this is what we all thought internally. Yeah, right. Okay. Anyway, so every single court to address this agreed uniformly that this was not a tax. It was called a penalty. Granted, it's paid to the IRS on your tax return, but it was called, called a penalty for failing to comply with this mandate. Okay? So the Fourth Circuit dismissed it. Okay? President was happy. So then we come to Don Verrilli, who was a Solicitor General of the United States. He's the top lawyer who argues all the big cases. He's going to be coming back again next week to argue another Obamacare case. It's become an annual tradition. He and Paul Clement argue about Obamacare every 2 years. It's actually kind of funny at this point. So the D.C. Circuit Court of Appeals, I was actually just there yesterday. I went to a lecture after my testimony, had arguments. And one of the Judge Kavanaugh, Bush appointee, very, very bright guy, he worked in the White House, made this one remark in his opinion. He said something like this, like, listen, we have this statute, right? And it calls it a penalty. What if we just tweaked it a little bit, right? What if instead of saying penalty, it said tax? If Congress had changed one word in the entire statute, this would be upheld in 5 seconds, right? Why would this be upheld in 5 seconds? Well, we've discussed the taxing power is much broader than the commerce power. Remember the license tax case, right? Congress could regulate and tax lottery tickets in one state, right? Congress can tax inaction. They do it all the time. We have an income tax, right? We have a capitation tax, right? Congress can tax you merely for existing. So what if Congress used the taxing power? The problem with this, of course, and Judge Kavanaugh is a very bright guy, he realizes, is this isn't what Congress did. That's not what the law said. But Judge Kavanaugh said, what if we pretend? Like, Mr. Rogers, land of Never Never Land, right? What if we take the trolley to Never Never Land or make-believe land, right? And we pretend this is what it says. As a court, do we have a constitutional duty to read the statute in a way to uphold it? Is what Connie asked about before. Can we read the statute in a way to find it constitutional? He didn't quite go that far, but when he made that point, the Solicitor General noticed it, and this went into his thinking of how to argue this case before the Supreme Court. Now, I hope all of you at some point in your lives get a chance to argue for the Supreme Court. Attend. I hope you will argue for the Supreme Court. Probably won't, but at least attend arguments for the Supreme Court. It's a masterful demonstration of advocacy. And this is a very special skill because you're framing arguments at such a high level of abstraction that you're not just affecting the case before you, but you're affecting cases to be decided 100 years from now. And it's a really remarkable experience. I just walked by there yesterday. I always go there for good luck. I always walk by there. So it was cold. It was cold yesterday. Actually, I'm glad I got on. My flight was delayed 90 minutes. I didn't land until about midnight. So it was a late night, but I'm here. So the case now with a circuit split 3-1 goes to the Supreme Court. And the justices are going to be forced to decide this extremely important constitutional issue. Okay? Here they are with the president. It's a tradition when there's a new president that they invite to the Supreme Court. They walk around, they take pictures. Here they look so happy and cheerful. But the relations aren't always so amiable, especially I think like the State of the Union. Okay, so Justice Alito did a big no-no in 2010, which you may recall. So generally during the generally during the State of the Union, the justices attend, and they're required to sit there literally sober as judges. They can't applaud, they can't clap, they can't stand up. They have to just sit there because they're not politicians. So during the 2010 State of the Union address, about a week earlier, the Supreme Court decided the Citizens United case. And we'll discuss this later, but this was a campaign finance case. Okay? And the president made various comments which weren't true. He said that this Supreme Court decision reverses 100 years of precedent. Not true. That it opens up the floodgates to foreign corporation spending. Not true. Anyway, Justice Alito, who's used to not having cameras on him, forgot where he was. This is not actually what happened, but he was mouthing not true. And this got caught on camera. Remember this? Okay, so we have here a history where the president is not afraid to criticize the justices to their faces. Literally, they're sitting right in front of him. And I think this is a very important precedent to discuss going forward, because there was a serious campaign after the case was argued to, I think, impact the arguments and impact the deliberations. So the Supreme Court has no cameras, and the only way to get in is to camp out on the street outside. There's no way to get a camera inside. I will give you a pro tip, because I've done this 3 or 4 times. The sprinklers come on at 2 in the morning. It's a very bad wake-up call when it's 30 degrees in the middle of March and the sprinklers come on. It sucks. The line for the Obamacare decision was 96 hours. The first person online camped for 96 hours. She was a single mother from Atlanta with 2 sick children. And she waited 96 hours. I interviewed her for the book. Remarkably, people are civil for the most part. They're civil. But the line is very long, and that week it was raining and cold and sleeting and snowing. So it's not a good experience. There are only 50 tickets given to the public for each case. So you have to get there early. So people always ask me, oh, Josh, hey, can I go to the Supreme Court? I'm like, yeah, go there the night before. I've waited as long as 13 hours. That's my longest one. And it's not a fun experience, because you can't really see it, but there's like a cement ledge there. And that's the only place for you to sit. And if you get close enough, the Library of Congress Wi-Fi will hit you, but you have to get just the right angle. And there are no bathrooms nearby. You have to go to the Union Station, which is a train station, which is a 15-minute walk. That's the only thing that's open at night. And there's like a McDonald's or something that's open. That's about it. So it's not a pleasant experience. But the scene outside the Supreme Court on decision day was one of ebullience. The Tea Parties were cheering, and the people were going no Obamacare and yes Obamacare and everything. It was a very interesting experience. Again, I was clerking in March, so I couldn't go to the arguments, which is why I'm making a point of going next Wednesday for King v. Burwell. So the arguments inside the Supreme Court are somewhat monastic. You have the bench up front. You have these rows of chairs, and you have these high vaulting ceilings. It's a very intimidating room. And what's really cool is at exactly 10 o'clock, like clockwork, if I may, the curtains part open and the justices appear. It's actually very cool. You'll never see it unless you're there because there's no cameras. But exactly 10 o'clock on the dot, they emerge and they sit in their chairs. And they actually have these people holding their chairs in place to actually help them in. Justice Ginsburg needs a little bit more help, but she gets in. They have to jack her chair all the way up so she can be above the bench. It's true. She's very small. There's a picture of me standing next to her, and she's like up to my here. She's very, very petite. So the justices decided that this was such an important issue, they needed 5.5 hours of argument. Usually a case gets 1 hour. The same-sex marriage case coming up gets, I think, 2.5. This one had almost 5.5 hours of oral argument. It was such a significant case. So it was over a course of 3 days. This was a marathon, a bizarre marathon, which I don't know we'll ever have again. On day 1 was the issue of tax. Could the court hear this now under the Anti-Injunction Act, right? Could the court hear this before the Obamacare tax was actually paid? So what's interesting here is the government argued that the Anti-Injunction Act doesn't apply, right? They said, no. Follow me very closely here. The government said, for purposes of the Anti-Injunction Act, this isn't a tax, right? The Supreme Court needs to hear this now. Why did the government argue that we need to hear this now and not in 2014? Anyone want to take a guess? Louder? Yes, exactly. What happens if you have a Republican president in 2014 who just decides, nah, let's not implement the law? Imagine that. By the way, Mitt Romney said he would not implement Obamacare. For all of you people with the Take Care clause, you had an entire Republican candidate. I'm not going to implement it. I'm just going to let it die, right? So for those who like the immigration policy, Obamacare. So yeah, so he's exactly right. There was no guarantee in 2014 there'd be a Republican president. And, they're not stupid. It's like, let's do this now. There's also a practical reason that they need to spend all this time and money implementing and planning it. And if the last minute court strikes down, it makes a lot of bad stuff. So they said, let's do this now. But this created difficulty for the government in a way that almost no one appreciates outside this room, right? What's the difficulty? The government just said it's not a tax for purpose of the Anti-Injunction Act. How can it be a tax for purposes of the Constitution? This was the genius of Don Verrilli, and I'm one of the few people give him credit, but I give him a lot of credit for making this argument. Okay? So again, on day one, the government argued Anti-Injunction Act. Day two involved the individual mandate. The individual mandate. Could Congress require individuals to purchase health insurance? Could Congress require individuals to purchase health insurance? Okay, so we've done this kind of thing before in the context of commandeering, you may recall. So in New York versus United States, Congress cannot require the states to take titles of the radioactive waste. Remember this? They cannot require states to take ownership of this waste. In Prince, Congress cannot require the sheriffs to run these background checks, right? This was a commandeering of state officials. But this case was something very different. It wasn't a commandeering of states or executive branch officials. It was a commandeering of the people themselves, right? It was requiring people to buy a commercial product. And this was something that had never been done before. That was frankly unprecedented. Okay? So on day three was a double header, as if it wasn't stressful enough. In the morning, they discussed something called severability, which I won't talk about much. But the idea is, what happens if individual mandates are unconstitutional? What about the rest of Obamacare, right? The government agreed, if you get rid of the individual mandate, the rest of Obamacare has to go. Why? You'll have this adverse selection death spiral. All these people will wait to the last minute to buy insurance. The entire market will collapse. I should add that when the government told the court they could not delay the Obamacare mandate, what happened 2 years later? We delayed the Obamacare mandate for 2 years. So the very thing which they told the court could not be delayed, the president delayed. I made this point in a brief to the Supreme Court, which they will ignore. But it drives me crazy to no end. So they just kind of waived it. They said, oh, there's a hardship, right? What's a hardship? The hardship was Obamacare, insurance is too expensive. So basically, Obamacare is the hardship itself. I don't think it's legal. Day three in the afternoon was the Medicaid expansion, right? Could Congress require the states to expand to 133% of the poverty line? Could they do that? Was that coercive? So the arguments went very interesting, right? And on the first day, it was Don Verrilli, the Solicitor General, versus Paul Clement. And Verrilli made the point very clearly that for purpose of the Anti-Injunction Act, this is not a tax. I'm sorry, it's not a tax. Okay? It was a penalty. But he made a very important point that most people missed. Generally speaking, if there's a crime, right, and you don't follow the law, you commit the crime, you're now a criminal. You go to jail, you can have your parole revoked, you can't have a gun, there are a lot of consequences. Is failing to buy health insurance a crime? Well, I thought it probably was, in the sense you're paying a penalty, you're paying a fine for failing to do it. But the government made a very precise argument. They said, listen, follow me very closely here. There is no mandate. Okay, here's the government's argument. There is no requirement to buy health insurance. The government's not requiring that you buy health insurance. What? What do you mean? This entire thing's about a mandate, right? The government argued there's no requirement to buy health insurance. Rather, there is a tax on not having insurance. I said it again. The government argued that there is no individual mandate. There is no requirement to buy health insurance. None. There's only a tax on not having health insurance. Everyone see what they did there, right? They basically eliminated the individual mandate from the entire law. There was no mandate to the government. There's only a tax on not having health insurance. Now you may ask, Josh, what's the difference between making me buy health insurance and paying a penalty versus taxing me for not having health insurance? What's the difference, right? The taxing power is a lot broader than the commerce power. Congress can tax inactivity. They can tax your failure to do something, but they can't fine you under the Commerce Clause.
Is that only because in the Constitution they don't regulate NFIB? Or wasn't that one of the arguments in the case where you're like, well, look, the Constitution doesn't explicitly say you can't regulate NFIB, so that way that comes from.
Kind of. But it comes more from the court's precedents going back to the 1800s saying the taxing power is much broader. What did John Marshall say? The power to tax, the power to destroy, and the check on the taxing power is politics. So the court has reined in the commerce. They've not reined in the taxing power. Yes, Hector?
I'm trying to tie in your comments regarding the criminal liability.
Yes.
Mandate. Are you saying that if it were a true mandate, one would be arrested for not complying?
Not necessarily arrested, but you have to pay a fine.
Oh,
A penalty, right? And actually, if I may, I'll get you in a second, Connie. Justice Sotomayor asked the question in arguments, Counselor, does the government consider it to be a crime not to have insurance? And he said no. That was such an important answer that people don't even appreciate. And the Chief Justice cited that very answer in arguments. So this was an aspect of the case people didn't even realize. Connie.
I'm just trying to say that it actually punishes the very set of people that they're claiming that they're going to help. I mean, the people that don't have insurances are going to get taxed and penalized. I mean, it seems to contradict. I mean, the whole policy seems to contradict.
Well, the policy is what it is, and we can talk about that after class. But the fact is, the government made this argument, and it worked. I'll get there later. Yeah.
Can you briefly explain the anti-injunction?
Right. This was a law that says you can't challenge a tax in court till you pay it. You have to pay it and then seek a refund. The Obamacare tax will not be assessed until 2014, so no one will be able to challenge until 2014. This was in 2012, so it's premature.
So then how did the NFIB get standing?
Ah, okay. And we'll get there in a few minutes, okay? So day two was actually the Commerce Clause challenge, and this did not go very well for the government. The general's biggest enemy was a glass of water. So this is a lesson to you if you ever make arguments in a court. Do not drink immediately before, because water goes down the wrong pipe. So you can listen to the audio on this. The Solicitor General begins, as he always does, Mr. Chief Justice, and may it please the court. That's the standard introduction. You always say it. He spoke for about 8 or 9 seconds, and then there's silence. Silence for about 8 seconds. He was choking. The water went down the wrong pipe. He couldn't breathe. You can actually hear, if you listen carefully in the audio, him going for a glass of water, the ice cubes clinking around and drinking. He couldn't breathe. So for 8 seconds, it was absolute silence. The biggest con law case of his entire career. He choked, literally and figuratively. So, but what's remarkable, you want to talk about advocacy? He had his opening committed to memory verbatim. So if you read the first few words before he choked, after he choked, he read them again verbatim. That is skill. Even after he literally could not breathe, right? The guy couldn't breathe. He repeated the words verbatim in his memory. I can't do that. I hope many of you can be advocates and do that, but that's an impressive skill. It went downhill from there. So the justices were beating up on the government saying, wait a minute. All of our cases say you can't regulate activity, right? How is this possible? And the general didn't have a very good answer. They said, what's your limiting principle, right? If they can do this, can they make me eat broccoli, right? Can they make me, I got this good picture. Justice Scalia asked, if we can do this, can we make you buy broccoli, right? Can we make you buy a GM car? And the government didn't have a very good answer to that either. So the arguments didn't go very well. And the last day on the Medicaid expansion, this was really interesting. Most people miss this also. They asked the government, what about this letter to Arizona? Right? What about this letter to Arizona saying that if you don't expand your Medicaid, you lose your entire budget? And the Solicitor General knew about this, and he said, well, I can't really represent what the position of the government is. The Supreme Court said, will you take away Arizona's entire budget if they don't expand it? And he said, basically, that's above my pay grade. What's interesting here, and this is real inside baseball you're getting from me, the Secretary of HHS, Kathleen Sebelius, would not let him answer that question. Why? Because they wanted to retain the power to take away the budget. The government wanted the power to take away the budget for non-compliant states. They would not give that up. So, if the government wouldn't give it up, the court will take it away from them. So anyway, after the case was argued, all the eyes were on Justice Anthony Michael Kennedy, Justice Kennedy, who's often viewed as something of a swing vote. But in reality, the attention should have been focusing on the Chief Justice, who would, as history turns out, be instrumental in deciding this case in a way that still surprised me every time I read it. I still shake my head every time I read it. So what we know is that at some point, the Chief Justice changed his mind. So, and I've done my own research on this, and you can read different reports, but my sense of it is this, that the initial conference, right, the Chief Justice was set in saying this violates the Commerce Clause, that Congress can't do this under the Commerce Clause. But he was on the fence about taxing. And at some point, not too long after, he decided to change his vote to uphold it under the taxing power. I'll explain this more in a minute. So as a result, the Chief issued a very complicated decision. And I want to walk you through it one part at a time. Okay? So in the first part, these aren't part numbers, but the first part of the opinion, I'm doing this mostly from memory, so I don't have the thing in front of me. The Chief Justice says, this is unconstitutional under the Commerce Clause, right? At this point in the courtroom, people were cheering, saying, yes, Obamacare's dead, it's done, it's done, it's done, okay? Why is this the case? The Chief said, well, because all of our cases involve activity. The regulation of activity presupposes economic activity. If Congress can force you into economic activity by buying insurance, they can make you do anything. This is a power Congress does not have. Okay? Yes, ma'am.
I just don't understand how, like, okay, so if someone doesn't buy insurance and they actually can't, like, pay for their medical bills and they go to, like, the hospital or the emergency room, they're, like, in the activity because in the end that is going to, you know.
When's that going to happen?
When it's, like, so the hospital, someone's going to have to pay for that eventually. It doesn't matter if it's, like, 1 people, 15 people, if it leaks. So
this was Plummett's point, which I'll get to in a minute, right? So this is the government's argument. The government says everyone will need health insurance. Everyone will need health insurance at some point in their life. Okay? So I have a couple of responses to this, which the Chief Justice says is that may happen, but that's too far in the future.
But today, people are going to the hospital without, like, it's happening today.
But the question is, how close of a fit must there be between Congress's powers and future problems? And this, if I can answer your question with the necessary and proper clause, right? This isn't exactly a regulation of interstate commerce, right? They admit that this is activity in one state. But under the necessary and proper clause, Congress can take additional steps to make sure the health insurance system works, right? So in order to prevent this cost shifting at hospitals, right? In order to prevent these adverse selection death spirals, Congress can require people to buy health insurance. Under the necessary and proper clause, is this a convenient way? Remember we said necessary means convenient. Is this convenient? Yeah. It's a convenient method to ensure that people are covered. But then the Chief does something really funky. We return to the second word in the Constitution. Proper. He says, even if this is necessary to have a good health insurance system like you're describing, it isn't proper. Okay? Why is it not proper? Because in the words of McCullough, this is a great and substantive independent power. You know the expression, the tail wags the dog, right? Where the tail's bigger than the dog? Kind of like that. That the power to make people buy insurance is so much greater than the regulation of health insurance market. This is such an intrusion onto individual freedom that this does not fit with the necessary and proper. Okay? As Justice Ginsburg notes in dissent, right? There is no exact line the Chief Justice draws, right? There is no line the Chief Justice draws about where this is. We don't know how much of a burden, how big this power must be for it to be unconstitutional. But for the first time ever, now we have limits on proper. That even if it's necessary, it's not proper. That the government can't make people do this. Okay? Justice Ginsburg replies in the exact point you made, Stephanie. Listen, this is stupid. Everyone's going to need health insurance, right? Everyone's going to die. Everyone will get sick. Everyone will need this at some point. Why can't the government regulate the manner in which people pay for it? They can either pay for it now or pay for it later, in which case they're shifting to the state to pay for it. 5 justices rejected this reading. Okay? So at this point, everyone's saying, yay, we're done, we win, right? Well, no. The Chief Justice says, we're not done yet, folks. We turn to the taxing power. This is where every time I read it, I'm going, oh my God, did this really happen again? And read how many times I read it, I'm like, this happened again. Okay, so what happened with the taxing power? The Supreme Court made this point by the Chief Justice, and follow this one very closely. For the purpose of the Anti-Injunction Act, it's not a tax. We can hear this case today. But for the purpose of the constitutional taxing power, we will construe it as a tax to save the law. So on the one hand, it's not a tax for the Anti-Injunction Act. On the other hand, it is a tax to save the law. The Chief Justice says if we have 2 ways of reading the law, to strike it down or uphold it, let's read it in a way to uphold it, and let's treat it as a tax. Even though he says it's not a tax, they label it a penalty, and labels matter. We will treat it. And essential to getting here was the fact that there is no crime. This was such an important point. There was no actual, the government said, there was no requirement. This was not how the law was designed. This is how the law was defended. And the law the court upheld was not the law Congress wrote. You're going to sense that as a pattern in a moment. So anyone have any question that the Commerce Clause, the Necessary and Proper Clause, or taxing power holdings? Yes?
Doesn't this set a confusing precedent?
Yes.
What?
You don't have to finish your question, but go ahead.
I don't.
I was being sarcastic. You can finish your question.
What exactly is the tax and what exactly is the penalty? And can the government construe
Yeah.
a penalty to look like a tax or a tax?
Exactly. And this creates a perverse incentive for members of Congress to lie. And when they're passing a bill, they go, oh, we're just going to call this a penalty. And the second you get to court, say, oh, just kidding, it's a tax. You're right. Yes, sir.
I know this is a fine line, but that has to provide some type of future insight.
Yeah, so the Chief Justice, I mean, we can discuss this later, but the Chief Justice was very deliberate at making this as narrow as possible. He wanted the government to win, but give as much as possible to the Commerce Clause. So you may ask yourself, if the court upheld this as a tax, why were there all those pages about the Commerce Clause? Right? Why is the judge who spent 40 pages discussing why this violates the Commerce Clause if it's okay to do a tax? Shouldn't have been, we find this as a constitutional tax, therefore we don't need to reach the Commerce Clause issue. Is that a dicta? The entire section? We don't actually know that. Hector?
Well, doesn't it seem like it would allow some leeway for the court to decide either way they want it on whatever issue?
In the future?
Turn it down here or accept it here?
You're talking about for the future cases? Hector's exactly right. The reason why I think the Chief Justice did this is to set a precedent for the future, to perhaps strike down something else later. I think that's exactly right. That's the best way I read it.
Seems to me a very convoluted way to get extra tax money in, because there are a lot of people who bought insurance, but then as soon as the act went into effect, the insurance premiums doubled, forced those people who did have insurance to no longer be able to afford insurance, but now they have to pay the tax.
Yes, and the tax will be increasing each of the next few years. Yes.
So
That's a policy question. We can talk about that later, but yes, that's correct. Anyone else from the Commerce, Tax, or Necessary and Proper Holdings? The final portion of the court's decision was on the Medicaid expansion. This is the one that took everyone, myself included, by surprise. Okay? What happened? The court said this: it's a violation of South Dakota v. Dole to take away the entire budget for failure to expand. What did the court do? They gave them a choice. They said, if a state wants to keep the old money, they keep the old money. If a state wants to expand, they can expand, but they have to take all these new conditions. So states had a choice. Rather than saying all states which wanted this money have turned it down, they said if a state doesn't want it, they don't have to. So as it stands now, there are about 30 states that have not expanded Medicaid. One of them is Texas, and there's actually a big debate about whether it will happen. I don't think Greg Abbott will do it. I think he'll be thrown out of office if he does. People are nodding. But there's a serious debate. So for now, we're the first time, for a lot of things, we're the first time we found a violation of the proper aspect of necessary and proper. The first time we have a violation of South Dakota v. Dole, the spending clause. This was a massive case. Ms. Connie?
Where would Medicaid fit on the different, would that be spending power?
Spending. Medicaid's a spending program. Okay. So there was a joint dissent, which is rare, by Justice Scalia, Kennedy, Thomas, and Alito. It was a joint dissent because they didn't sign it individually. They all signed it together. And what's interesting is that they didn't join the Chief Justice's decision, right? Even though they agreed with him in the Commerce Clause and the Necessary and Proper Clause, they wrote their own analysis. Now, there's some speculation that the conservatives are trying to lure the Chief Justice back in and have him join his opinion at the last minute, but I don't think that's very accurate. The opinions were written well in advance. There's a dissent by Justice Thomas, which was excerpted, where he basically said, I would reverse the 20th century. He would say, all these cases are wrong. Let's get rid of Wickard. Let's get all these cases. Let's go back to the original meaning of the Constitution. Justices Breyer and Kagan, very interestingly, joined the Chief Justice's decision on Medicaid expansion. There were actually 7 votes to find the Medicaid expansion unconstitutional. This was not a 5-4 aspect of the case. Justice Ginsburg and Sotomayor would have upheld the ACA in its entirety. And they had they excerpted a small part, but Justice Ginsburg had very strong tones to the New Deal, saying, look, this is like Social Security. The Supreme Court should not be getting away these massive social programs. Last time we did that, we got in trouble. Let's not do this again. And I think her point is well taken, right? Had the court actually invalidated this, I think the president would have severely criticized the court and run on the court in the next election. Okay? That's all I have for today. Are there any questions or comments? I apologize for lecturing more than I like to, but this is the only way to get it done in one day. All right, got it done in time. Great day, everyone. I'll see you all on Tuesday. Thank you.